Homes Inc. of Florida and J-Rod Plastering LLC versus Southern Owners Insurance Company. Tracy Ransom, Andrea Ransom, Nation Insurance Agency Inc. and Renee Klein, 23-1463, consolidated with 23-1545. Each side has 20 minutes. Calvin, I have 5 minutes as a default rebuttal time unless you want more or less.
No, sir.
5's good?
Yes, sir.
All right, counsel, whenever you're ready, sir.
PRC Cord, sir, on behalf of Miranda Homes. The question is, why are we here today? We're here today on a de novo review of a motion for summary judgment. We have decided to limit this case to simply the duty to defend. We have our own reasons why we believe that's the only area of damages that we have, so we decided to limit this case to the duty to defend. Everyone in this case agrees on the basic fundamental case law.
Mr. Secord, if
Yes.
I may, just for contextual, because of who we have in the gallery here, I promise not to take too much of your time, but you're talking about a motion for summary judgment. In the previous case, we were talking about a motion to dismiss.
Yes, sir.
So there has been, you have gone past the pleading stage, there has been either a motion to dismiss or an answer to the complaint, and now the parties have undergone what we call in the legal world discovery, and you are now at the final phase before you arguably go to trial, which is a motion for summary judgment. Is that correct?
That is correct,
All
sir.
right, thank you for indulging me.
And I apologize.
And I understand that, but some people,
And
I don't want to get you nervous. I do understand that.
I should consider my audience, so I apologize.
So you're comforted by the fact that Judge Wallace understands that.
Yes, Your Honor.
You have one.
I got 1 out of 3.
I did see his degree. So really everyone agrees in this context, what we're talking about, just to talk to this class a little bit, is a duty to defend under an insurance contract. In order to have a duty to defend under an insurance contract, you must have some sliver of potential indemnification.
So in other words, you guys got sued by the homeowners because the stucco was, they said the stucco was defective, and then you turned to your insurance company, that side over here, and said, okay, we're being sued, please defend us. Please hire lawyers to defend us in this lawsuit, because that's why we paid you guys for insurance. And their position was, we don't think it is a covered event. It's not covered under the insurance policy, so you guys are on your own. Good luck.
That is correct.
I mean, probably politer than that.
They were very polite.
Yeah.
But the long and short of it is they decided not to defend us under the contract of insurance. So in order to decide what
extra time, more than 20.
I'll get through it.
All right.
So as it relates to the duty to indemnify, there are only 2 things that the insurance company should be looking at for the duty to indemnify. The first thing they look at is whether there's potential coverage, and the second is, does the complaint plead anything that might be covered under the policy? It doesn't have to end up being covered under the policy.
You indemnify, you mean defend?
I'm sorry, duty to defend. I apologize, I misspoke, Your Honor. Duty to defend. So what do we have in this case? We have, everyone agrees, if J-Rod's negligence caused bodily injury or property damage during the ongoing operations.
Can I ask, just from a logical standpoint, or maybe my logic, for lack of a better word, if you're conceding they don't have to indemnify, so whatever it is that ends up the homeowners are owed by your side, they don't have to pay it. If they don't have to pay it, why do they have to defend you?
Because I'm not making a claim for the duty for indemnification, Your Honor. To be honest with you, in this particular case, a subsequent insurance company has paid the indemnification. So it no longer becomes necessary. I don't even have that as a damage anymore. So I can't make that claim. I'm not saying they don't have a duty to it, but if I don't have the damage, I can't make the claim.
I was just unclear as to how somebody has a duty to defend something that they never have to pay. But there's a reason why they don't have to pay unrelated to the contract.
Right, but in addition to that, Your Honor, when you look at the case law, you're not supposed to be looking at whether they would eventually win.
No.
The duty to defend starts the second that complaint is filed, and it doesn't matter whether eventually it's proven they have no duty for indemnification. So the key question here is...
If on the face there was no duty to indemnify.
If on the face.
Okay.
If on the face. But what we know here is J-Rod has conceded that if during ongoing operations there was some type of damage to property, they've agreed that it's covered. That's covered in Southern's response to our motion for summary judgment, record on appeal 236, and in the court order, the court accepted the fact that if damage occurred to other property during ongoing operations, it was covered, and that's the court order, Record on Appeal 282.
Well, let me ask somewhat ironically to carry over from our first case here. So the homeowners, you guys finish your work, the homes are sold. Years later, the homeowners are, at some point, the homeowners are complaining about the stucco.
Yes, sir.
So does the insurance company just have is it a never-ending duty to defend or to pay on any stucco claim 20 years down the road?
Well, there's always a statute of limitations issue,
Okay,
but that didn't happen.
When does the statute get triggered? I mean,
Well, that hasn't been raised in this case, so I didn't look at the statute of limitations issue in this case. But the issue is, this is an occurrence policy. It's not a claims made policy. So the question is, during the occurrence of the policy, was there damage to other property? Or not just was there damage, was there potentially damage when you look at the complaint? That's the key issue.
The judge relied heavily on the stucco exclusion.
The court, yes, they did.
Your initial brief says what about the stucco exclusion?
The stucco exclusion is irrelevant because the court also ruled that if the injury or damage to the property occurred during the ongoing operations, there was coverage. And the court had to do that because if the court didn't do that, and if J-Rod didn't concede that, this is an illusory policy. You charge $350 for something you didn't give.
On the stucco exclusion, though, it says as far as ongoing operations, that it only provides or only covers bodily injury, not property damage.
Again, Your Honor, the way they interpreted that, and I'll read directly from the court's order, they agreed if J-Rod's negligence caused bodily injury or property damage during ongoing operations, there was coverage. And that's the court order on 282 record and Southern's response to our motion for summary judgment. So, Your Honor, the court had to accept either there was an ambiguity in the exclusion or it didn't apply to ongoing operations. Otherwise, it would have been a illusory policy. And I also want to point out judicial estoppel. Southern owners took that position in the motion for summary judgment and allowed the court to accept that position in the motion for summary judgment. And therefore, they're judicially estopped from now coming in and saying that exclusion applies to ongoing operations. And that's
The court relied on the stucco exclusion, and you don't address it one time in your initial brief. Have you waived any challenge to that?
Absolutely not, Your Honor, because they agreed that there's coverage for that. In other words, Southern auto owners, in their response to the summary judgment, and I'll tell you again, record 236, agreed that there's coverage for ongoing operation, and the court adopted the fact that there was coverage for ongoing operation on the record on 282. I would cite the court to, hold on one second, Your Honor. The judicial estoppel law, and that is Collection Center versus Alexander, 41 Florida Law Weekly, District 999. And that's the concept that you can't take inconsistent positions. In their underlying case, what they said is, look, we agree that for ongoing operations there is coverage, and they had to take that position because if they didn't, they would have lost because it's an illusory policy. So that's our position, Your Honor. And I think that they would have lost because they charged $300 for something that simply then wouldn't exist because the stucco exclusion would exclude everything, potentially. Going on to the analysis of the complaint. So then what you do is, in order to decide whether there's a duty to defend, you look at the complaint. And in this particular case, there are several paragraphs that are illustrative of what the issues are in this case.
You're talking about the complaint, you're talking about the notice that the homeowners gave to your client as far as how they fell short of the construction. That's the complaint you're talking about, is that correct?
You know, that was inartfully argued, Your Honor, in our motion, to be honest with you. I think what we really are stuck with is the actual complaint itself, the Ransom versus Miranda case complaint, and the Ransom versus Mandelanson, and the Ransom versus all of the ones that involve different plaintiffs, where they were basically suing us in 5 different cases are being consolidated. That's the case that really the case law says we should be looking at. And so when you look at that particular case, and an example is Ransom, they're all identical. They all have the same type of allegations in them, and they all have, not all of them, but most of them have the structural engineering report also attached to them. What you do is you go to the complaint and you look at paragraph 27, and that's the key paragraph in this particular case, Your Honor. And what it talks about is the different violations that occurred in this particular case. The most important things on there are this. In 27C, there are missing accessories at all locations where vertical and horizontal surfaces meet. The problem with that is it allows water intrusion in between coating. If you look at F of number 27, it indicates the stucco was not cured properly with sufficient time between coats. So what you have is you have a situation where you're missing parts in the actual stucco. It's allowing water to come in between your 3 coats of stucco that have to be put on this, and it's causing damage to other property, or it may cause damage to other property. So the key question is when you look at the complaint,
Weren't all of those allegations arguably things that occurred during the process of stucco application?
well, yes, all of it occurs during stucco, but that's why it's an ongoing operation claim, because it's all happening during the ongoing operation. I agree, and that's why it's covered. And so when you look at that and you look at the issues in this particular case, you have to ask yourself, is there even the possibility that any of this could potentially be covered? And if the answer to that is yes, you should come to the conclusion that, hey, you get a defense. Whether you eventually get indemnification on this or not, who knows? I don't know what the facts are going to play out in the case, but we're not supposed to look at the facts. What we're supposed to do is look at the complaint and look at the policy. Continuing on. So,
Actually, you are looking at the facts. If you're talking about being at the motion for summary judgment stage, you're looking at whether or not there is any genuine issue of material fact. So you absolutely are looking at the facts, and you're basically telling the court that under the facts that are the part of this case, and there's no way that there could be any sort of where the appellee would prevail in any way, shape, or form, because you've looked at the facts, correct?
no, I don't mean to say no like that. What I'm saying is when you look at the summary judgment, it was looking at 2 issues, both the issue of liability and the issue of coverage. What we're saying is the trial court looked at just the issue of coverage, i.e. indemnification, and didn't really look at the issue of whether there should have been a cost of defense. That's what we're saying. So yes, you have to consider all those facts when you're looking at the indemnification issue, because it is a fact issue. When you're looking at whether there's illusory coverage, absolutely you have to look at it because it's a fact issue. But when you're looking at it from a from a cost of defense issue, that's a different analysis. And the court used the indemnification analysis instead of using the cost of defense analysis. That was the problem, in my humble opinion, in the case. And they also talked about in their reply brief about a completed operation exclusion doesn't apply to us because we have an exclusion for the additional insured on completed operations. Where our whole point is our argument is that this comes under the ongoing operations, which is a separate part of the policy, which they conceded as part of their argument in the motion for summary judgment, and the court underlying us adopted. So not only did they concede it, but the court, based on that, adopted it and decided there wasn't illusory coverage, partly because of that. So the next issue that we look at is really, what does the case law say with regard to all this stuff? Let me just flip to that, sir. We all know that under Florida law, if a complaint is silent as it relates to when the damages occurred, the damages are presumed to have occurred within the policy period, if they could have occurred within the life of the policy. That's the Trizec, T-R-I-Z-E-C Properties, Inc. case. The complaint in that particular case was silent as it relates to the damage that was caused by the roof installation. And what the court eventually ruled is, because the complaint alleges facts which fairly bring the case within coverage of the insurance contract, there is a potential for coverage, and Liberty owes Dex a duty to defend in the main action. That was an occurrence-based policy, just like ours is. The underlying damages in this particular case aren't specified as to when they occurred in the complaint, but they certainly allege that it was a process that occurred over time while this stucco was being applied on multiple occasions. So one can...
Prior to the home being completed.
That is correct, Your Honor.
All right, and
prior to the work being done.
Right, and so the judge is looking, the trial judge below is looking and saying, okay, reading in the complaint, a homeowner who got the property after the work was done is making a complaint that the stucco was not properly applied. And so there is some time frame there as to when the damage occurred. These, maybe not the exact date, but after the home was completed.
Well, no,
Is that what the judge?
I think that's what the judge ruled.
Right.
I think that's what the judge ruled, but that's not the analysis you use on a coverage defense. The analysis you rule on a coverage defense is not whether that damage actually factually ended up being later or not. The analysis is under the complaint, as alleged, was there a duty to defend? Not a duty to indemnify, but a duty to defend. And that's what these courts keep saying over and over and over again.
So if the lawsuit was filed 15 years after the homeowner took possession of the property, they would the judge could look at the complaint and say there's no duty to defend.
Then you pass the 5-year. Then you pass the 5-year statute of limitations on a contract action. So that's gone. So I don't know that you could sue the insurance company in that situation. I don't know. I haven't analyzed that issue, Your Honor. I can only analyze what I have in front of me. And that's
So in essence, the coverage is your position is the coverage is 5 years after the home has been accepted by the homeowner.
I think I'm not taking a position with regard to the statute of limitations because I haven't analyzed that issue. What I'm saying is, in this particular case, the court has to look at the complaint. The complaint was timely filed. They didn't raise the statute of limitations defense. We didn't raise the statute of limitations defense. Nobody's raising that as an issue. What they're saying here is they agreed that for ongoing operations, there's coverage for property damage. Once they agree that there's ongoing operations coverage, so once they reach that threshold and you cross the Rubicon, and they've agreed that yes, for ongoing operations, there is potential coverage for property damage. Once you cross that Rubicon, then you go back to the complaint. You say, okay, is there an allegation in the complaint which might indicate that there is coverage for, there was damage that occurred during ongoing operations? And clearly the answer has to be yes. Because when you look at the complaint, it clearly alleges that there was missing parts and that this stuff was being put on over time and rain could have damaged it then. In fact, it says that they allege it was caused immediately or caused shortly thereafter while they were in the process. At least from my reading of it, that's a reasonable reading. In addition, Your Honor, we pointed out the Travelers property casualty case, 161 Fed Sup 3rd 1133, and I think that's instructive as well. It involved the stucco case regarding the completion of the project after the subcontractor had left the project and after the project had been turned over to the condo and after the certificate of occupancy. It's almost exactly like this case. Several years later, the association filed a complaint in state court against the general contractor alleging defects and against the tradesmen, or multiple of them. The court held there was a duty to defend and that the insurance company had wrongly refused. The court entered a summary judgment against the insured, finding that the condominium association state court complaint could be interpreted to mean that the damage caused by the subcontractor occurred during the policy period, either after the completion of the subcontractor's work or while that work was ongoing. Either one of them was potentially covered. Now, in our case, I agree that the court has ruled that afterwards, in the completed operation, it doesn't apply, but we're arguing that we're doing the ongoing operation.
Down to 2 minutes.
Yes, sir. Oh, then I'll rest right now then and reserve the rest. Thank you, Ron.
Good morning, Your Honors. May it please the Court, Jennifer Bridges with Burr Foreman on behalf of Appalachia Southern Owners Insurance Company. The trial court reached two main conclusions in entering summary judgment below. Number one, that the homeowner's underlying property damage claims relate to or arise from J-Rod's stucco application work and thus fall within the scope of the policy's stucco exclusion. And number two, that the stucco exclusion does not render these policies illusory. Remarkably, J-Rod and Miranda in their initial briefs do not address either of these issues, including the issue of whether or not the policies are illusory, which is an argument that my esteemed colleague raised several times during his opening oral arguments to you today. Instead, J-Rod and Miranda focused in their initial briefs on the timing of the alleged property damage in question. But under the plain language of the stucco exclusion, this issue is irrelevant. Judge Harris, I read the stucco exclusion the way that you do. The stucco exclusion provides that any claims that arise from or relate to the stucco application work that J-Rod did are excluded from coverage. The only type of claims that are allowed are bodily injury claims that occurred during ongoing operations.
Isn't the use, counsel, Ms. Bridges, isn't the use of the word illusory and whether or not it is illusory begs the question which requires you to interpret the contract. Is that correct?
Well, first of all, Your Honor, I believe, first, as I mentioned, that this issue is waived. That aside, you would have to interpret the effect of the contract, but these, in order to be illusory, the stucco exclusion would have had to render the policies to be completely meaningless.
But that requires you to define the terms and understand the terms of the contract. You would agree?
And the terms of the contract, Your Honor, are clear and unambiguous, as Judge Aho found in her extensive summary judgment ruling, and after the more than 3 hour hearing that occurred on our respective motions for summary judgment.
You won below. So, of course, you're going to make that argument that you won below. But if you didn't win below, it would be up for a jury to decide the terms of the contract and whether or not the contract should be interpreted for or against coverage or not, correct?
No, Your Honor. Summary judgment is appropriate in these types of cases where it is plain from the language of the face of the contract that that there is no possibility of coverage.
So, and you're saying that these contracts is what you're telling me is you never get to a jury trial when you have a contractual dispute between coverage or not coverage?
When it is plain from the face of the contract that there is no possibility of coverage, yes, Your Honor, I do not believe that it gets to a jury trial.
But you have to have somebody examine the terms of the contract to determine whether or not it's plain and clear, correct?
Yes, Your Honor, you have to have, if the policy has clear and unambiguous language, if the nature of the homeowner's claims are plain on their face, here we have underlying property damage claims, which are directly addressed by the clear and unambiguous language of the stucco exclusion, and the fact that the underlying claims related to or arose from stucco application, the court in the Northland Casualty Company versus HBE court case stated that summary judgment is appropriate in declaratory judgment cases such as this one when an insurer's duty, if any, rests solely on the applicability of the insurance policy, the construct and effect of which is a matter of law.
If the terms are not clear, or if they're subject to multiple interpretations, the contract is to be interpreted against the party that drafted the contract and in an insurance scenario in favor of coverage. You would agree?
If there was an ambiguity, Your Honor, then yes, that would be up for the finder of fact. However, that is not the issue that we are here on today. The sole issue that J-Rod and Miranda raised in their initial brief is the issue of the timing of damages. And that, under the stucco exclusion, is simply irrelevant.
Your opposing counsel, I think, said that you guys crossed the Rubicon, where that is, but you crossed the Rubicon somewhere. This is conceding with an ongoing operations coverage, and therefore the stucco exclusion is not really pertinent to that.
Yes, I heard that.
Make that correct, and maybe I misheard it.
So the argument that we have conceded this, I believe, references an illustration that was made during the 3-hour summary judgment hearing, in which there was the example made that if J-Rod had broken a window while it was on the job site during ongoing operations, that could have been subject to coverage. That example pertains to not work that J-Rod was doing performing stucco application. Anybody could break a window on a job site. A plumber, an electrician, anybody could break a window on a job site outside of the scope of their work. So, for example, if somebody on J-Rod's crew who was on the job site was holding a hammer in their hands and they accidentally swung their arm back and they broke a window during ongoing operations, there could be coverage for that. But if J-Rod was in the middle of performing stucco application work and broke a window, or if a scaffold fell and a heavy bucket of stucco fell on somebody and caused bodily injury, that would be bodily injury during ongoing operations. That would be
That was
covered.
covered. So
Yes.
they're saying this is illusory, when basically they're saying to you guys, or they're arguing to us today, saying, well, what did we pay our premium for? You know, we finished the work, now there's problems with the work, the homeowners are complaining, they come into us and we pay premiums to you guys, and now you say, well, you know, once you left the job site, all done, no coverage. So what did we actually pay for?
Yes, sir. And
What did they pay for?
well, they had $2 million limits, $1 million per occurrence for bodily injury claims that occurred during ongoing operations. They could have obtained coverage for the kind of example that I just gave you if there was negligence outside of the actual stucco application work that was done. But as the court stated in the Bitco case, which we cited to in our answer brief, J-Rod and by extension Miranda, they bought the coverage that they bought. They cannot now come back and complain and put it on the insurer that they are unsatisfied with the coverage that they received. The fact
So
is,
basically your position is when you guys finish your stucco work and the certificate of occupancy accepted and all the new homeowners got it, whatever's wrong with the stucco, we do not cover that at all. You got what you paid for, and if you wanted more, you could have paid for more, and you didn't. So we don't have to indemnify, and because it's clear we would never have to indemnify, we don't have to defend under the limited scenarios.
that's right, Your Honor.
That's your argument.
That is my argument, and in fact, I'll go a step further. Even if during ongoing operations there was property damage that occurred as a result of the stucco application, the stucco exclusion provides that those types of property damage claims are not covered.
So they're not covered.
No, sir.
So if the stucco applier had broken windows there or damaged plumbing and J-Rod or Miranda or whomever came and said, hey, we got, this is costing us more money, or costing more money, and we have to fix this. This is, please reimburse us or indemnify us, or you'd say, no, that's property. If the stucco guy broke a window and it hit somebody's arm and they had to get medical care, that's bodily injury, that would have been covered.
That would be bodily
Yeah, that's
injury,
what
that
you
would be
paid
covered.
for.
That's correct, Your Honor. And as the court stated in Bitco, quoting from that, considering the potential consequences of the EFIS exclusion in that case in light of the nature of the subcontractor's work on the project, the cost of their failure to obtain additional coverage cannot be imposed on the insurer after the fact.
The EFIS,
EFIS,
external insulating and finishing system?
yes, Your Honor. So in that case, there was an EFIS
EFIS sounds
exclusion.
better than
That's a pitch of baseball.
EFIS.
Yes.
Oh.
OOFIS.
We have around my office we shorthand it by saying EFIS, but perhaps I'm pronouncing it incorrectly. But the idea being that in that case we had a similar type of exclusion, and the fact that the insured chose to buy that policy that it bought, it cannot change that
This
choice
is a
now.
CGL policy, right?
Yes, it is. Yes. So, Your Honors, there is no question that the damage alleged by the homeowners here falls within that stucco exclusion, and where you have claims that are specifically excluded from coverage, there is no duty to
Well,
defend.
Mr. Secor seemed to say you guys are judicially stopped from making these kind of orders. What do you think about that?
Well, first of all, Your Honor, that's the first time that I've heard the term judicial estoppel raised at any point during these appellate proceedings was today during oral argument. That was not an issue that was
You've heard it
raised.
before, but first time today.
Yes, sir. That was the first time that issue has been raised. They did attempt to argue in their reply brief for the first time that we had conceded, using this window example, that property damage during ongoing operations is covered. The issue of judicial estoppel was not raised in their initial briefs. The issue of concession was not raised in their initial briefs. The only thing raised in the initial briefs was whether or not the underlying alleged damage occurred during not even during ongoing operations, but during the policy period, which is even a further step removed and further irrelevant from the issues of this case. All of those issues are waived, Your Honor. The only thing that the court should determine now on its de novo review is whether or not the trial court correctly read the clear and unambiguous language of the stucco exclusion to exclude the alleged property damage claims that are asserted by the homeowners in this case, and therefore, where there is no coverage and no possibility of coverage, whether or not there is a duty to defend, the trial court correctly found there was
interpret their
not.
argument to be that it's basically, I know that statute of limitations has not been briefed, but basically there's 5 years after the completion of the work that the homeowners have a chance to bring a claim under the policy. After that, it would be past the contractual 5-year statute of limitations that we.
Yes, Your Honor, I believe.
Yes, in the last,
I do believe that the statute of limitations would apply at that point, but that does not change the.
It doesn't matter from your standpoint, but that's part of their argument is that just because we finished the work, that didn't end the exposure you guys had, and therefore the duty to defend, which is more broadly construed than the duty to indemnify.
Certainly, and if there had been a bodily injury claim that was asserted regarding the stucco application work during ongoing operations, that might have been correct. But at this point, the statute of limitations is, as you noted, an irrelevant issue as far as we're concerned because there was no coverage to begin with for the underlying property damage claims.
We apparently just have statute of limitations on our mind after the last one.
I understand that, Your Honor. May I answer any further questions for the court?
Yours.
Thank you, Your Honor.
Second, Counsel. Oops.
I'll try to be mighty quick, Your Honor.
Well, it says 157, but like I said, due to law, so that actually was irrelevant.
I'll try to be mighty quick there, Your Honor.
More time.
Real quick, Mr. Justice, who knows a lot more than I do on statute of limitations, can give you the answer. It's a 10-year statute of repose on homeowners' defects, and it's 4 years from the date the homeowner knew or should have known of the alleged defect. So that's the correct statute of limitations analysis should that become an issue to you. Your Honor, my esteemed colleague points out that we didn't mention
Which one? That side or that side?
this side. They're both very esteemed. Your Honor.
Who's the esteemed one?
Points out that we didn't bring it up in our initial brief. Well, heck,
Didn't have a reason to.
I didn't have a reason to until all of a sudden they started arguing that, oh my gosh, the entire exclusion applies, when in fact, when you look at their brief and you look at what the court adopted to get past our allegation that it was an illusory contract or illusory coverage, both the court and J-Rod and the Southern Auto Owners agreed that if J-Rod's negligence caused bodily injury or property damage during ongoing operations, there was coverage. And again, I just point to the court order at 282 and J-Rod's response at 236. That's the only way you can interpret those documents. And you cannot take inconsistent positions. What they want to do is they want to go to the lower court and say, aha, there's a sliver of coverage, and here's 2 examples that there are slivers of coverage. But when they come to the appellate court, they want to say, no, everything's wiped out for bodily injury. And that is an inconsistent position which should be not looked at by this court under the concept of judicial estoppel. I also looked at the couple of cases that they cited. Northland was a trial court in the Middle District, and all it said was the standard for summary judgment. Bitco, it was also a trial court, and said that the glass was defective and it didn't cause property damage, and that's why there wasn't coverage. So those 2 cases really are not applicable to this particular case. I believe that estoppel should apply, and I believe that based on a reasonable interpretation of the policy, the damages may have occurred during the ongoing operations. Thank you, Your Honor.
All right, thank you.